Today's topic is the Convention on the Elimination of All Forms of Discrimination Against Women, CEDAW, of 1990. Preamble of the Charter of the United Nations. The preamble significantly argues that one of the UN's central goals is the reaffirmation of faith in fundamental human rights and equality of men and women. The Article 1 of the UN Charter proclaims to achieve international cooperation in promoting and encouraging respect for human rights and fundamental freedoms for everyone. The international obligations of the members increased to such an extent that it went on to propound newer concepts, consensuses, treaties, and instruments one after another. The Convention on the Elimination of All Forms of Discrimination Against Women, popularly known as CEDAW, is one such obligation that several members of UN have contracted to protect the rights of women. Just a year after the establishment of United Nations in 1946, Subcommission Systems on Human Rights was converted to a full Commission on the Status of Women, CSW, as a result of incessant women's activism. From 1949 to 1959, the CSW generated international energy on protecting the rights of women, as a result of which many conventions were adopted in the subsequent years. A select committee of CSW began the work of drafting in 1965. It would not be wrong to argue that the 1960s and 1970s witnessed a commendable rise in the concern for stopping discrimination against women. CEDAW was conceptualized on 18 December 1979 at New York. Officially, the convention came into force on 3 September 1981 as per the Article 27, Clause 1 of the Convention. The Convention on the Elimination of All Forms of Discrimination Against Women was adopted by the General Assembly in 1979 by votes of 130 to none, with 10 abstentions. Under the aegis of UN General Assembly Resolution 34/180, the Convention was formally adopted. The Convention set qualitative precedents on United Nations efforts to codify comprehensive international legal standards for women. The outcome of the Convention is such that it provides the basis for realizing equality between women and men, irrespective of gender, caste, creed, and social background, etc. Countries that have ratified or acceded to the Convention are legally bound to put its provisions into practice. They are also committed to submit national reports at least every 4 years on measures they have taken to comply with their treaty obligations. CEDAW consists of several layers of operational norms. To many, the operational norms is made of a complex network of procedural terms and conditions, say permissible and impermissible reservation system, undoing of reservations, reporting systems, etc. Such complexity perhaps reflect the critical aspects of any international system. CEDAW is nowhere an exception. For example, one can discuss about reservation system. While ratifying CEDAW, a member state can opt for reservation procedure. The reservation system may have empowered a state to reject, resist, or distance itself from the obligations of CEDAW, at least partially or to a particular section of the Convention. Provisions for reservations can be registered on the grounds of national interests, tradition, customs, religion, or culture. All reservations do not necessarily reflect reasonable and justifiable realities. One can argue that the provision for reservations has been rather misused to manipulate perspectives on the praxis and philosophy of CEDAW. Accepting the complexity of the reservation system, the Article 28, Paragraph 2 of CEDAW has a provision for the impermissibility of reservations. It states that a reservation incompatible with the objective and purpose of the present convention shall not be permitted. Acknowledging the sensitivity of alienating any potential member, CEDAW does not entirely disband a member from joining CEDAW. However, the Article 2 of CEDAW has experienced a maximum number of objections under the provision of reservations. CEDAW holds the view that the parties which ratify the convention do so because they agree that discrimination against women in all its forms should be condemned and that the strategies set out in Article 2, subparagraphs A to G should be implemented by states parties to eliminate it. Hence, neither traditional, religious, or cultural practices nor incompatible domestic laws and policies can justify violation of the Convention. One of the strong areas that the Convention perceives as impermissible is the Article 16, no matter even if it is raised on national, traditional, religious, or cultural regions. In order to resolve the complexity created by reservation system, the Committee on the Elimination of Discrimination Against Women considers that those state parties which have entered reservations to the Convention have certain options open to them. Till date, few reservations to Article 2 have been withdrawn or modified by any state party, and that reservations to Article 16 are rarely withdrawn. CEDAW consists of several support systems. CEDAW structurally is made of a complex network of procedures, along with several terms and conditions, which include committee system, optional protocol system, reporting system, etc. The Committee on the Elimination of Discrimination Against Women, established under Article 17 of CEDAW, has certain responsibilities as the body of experts charged with the consideration of periodic reports. The committee dwells on a constructive dialogue with the state parties and procedures of reservations. As it consists of experts, the special rapporteur considers that control of the permissibility of reservations is the primary responsibility of the state parties. The concept of optional protocol within CEDAW includes two important procedures, which are the communications procedure and inquiry procedure. Optional protocols to human rights treaties are treaties in their own right and are open to signatures, accession, and ratification by countries who are party to the main treaty. There is also the communications procedure that gives individuals and groups of women the right to complain to the Committee on the Elimination of Discrimination Against Women about violations of the Convention. Another system which plays a significant role in stock-taking is through country reporting system. Countries that have ratified or acceded to the convention are legally bound to put its provisions into practice. They are also committed to submit national reports at least every 4 years on measures they have taken to comply with their treaty obligations. Country reporting is enshrined in the Article 18 of CEDAW. There are other systems which come along with CEDAW. For instance, according to the inquiry procedure, it enables the committee to conduct inquiries into grave or systematic violations. An inquiry procedure enables the committee to conduct inquiries into serious and systematic abuses of women's human rights in countries that become state parties to the optional protocol. The model of inquiry procedure is derived from the Article 20 of the International Convention Against Torture and Other Cruel, Inhuman or Degrading Treatment or Punishment. Ground reality in India is that the ratification of CEDAW by India did not reduce violence against women. One of the reasons for this, perhaps, lies in the fact that the international agreement was not legally implemented and enforced throughout the Indian society. India's ratification of CEDAW in July 1993 has not been a mere acceptance of the convention, as India has come up with 2 conditional declarations while accepting CEDAW. India's conditional declarations vis-a-vis CEDAW are as discussed below. 1. With regard to the Article 5 Clause A and 16 Clause 1 of the Convention on the CEDAW, the Government of India declares that it shall abide by and ensure these provisions in conformity with its policies of non-interference in the personal affairs of any community without its initiative and consent. 2. With regard to Article 16 Clause 2 of CEDAW, the Government of India declares that, though in principle it fully supports the principle of compulsory registrations of marriages, it is not practical in a vast country like India with its variety of customs, religions and level of literacy. As a result, India has not ratified the optional protocol to CEDAW. The meaning of ratifying the optional protocol would make a state recognize the competence of CEDAW. The wholesome outcome of the reservations expressed by India is its non-compliance with regular reporting obligations. The Constitution of India upholds that it shall endeavour to foster respect for international law and treaty obligations. However, international conventions and laws are not very effective unless they are translated into domestic laws. The failure to contain increasing crime against women and inability to bring out an effective legislation on women's reservations are the imageries of India's incomplete response to CEDAW commitments. In countries that have ratified CEDAW, women have partnered with their governments to engage in a national dialogue about the status of women and girls, and as a result have shaped policies to create greater safety and opportunity for women and their families. The improvement of literacy and educational opportunities in Bangladesh in the recent times has been credited to CEDAW with a marked improvement in gender parity. The experience of Mexico in dealing with violence against women relied on CEDAW principles. Today, there is a general law on women's access to a life free from violence in Mexico since 2009. The impact was so wide that CEDAW principles have been evoked in Kenya to address differences in inheritance rights, eliminating discrimination against widows and daughters of the deceased. Similarly, the Kuwait Parliament voted to extend voting rights to women in 2005, following a recommendation by the CEDAW Committee to eliminate discriminatory provisions in its electoral law. Thus, the impact of CEDAW is neither country-specific nor region-specific. No doubt, CEDAW is a pragmatic international agreement addressing the rights of women and girls. CEDAW can make a difference for women and girls, specifically to reduce sex trafficking and domestic violence, provide access to education and vocational training, ensure the right to vote, end forced marriage and child marriage, help mothers and families by providing access to maternal health care, and to ensure the right to work and own a business without discrimination. Unfortunately, the US is one of only 6 countries, including Iran, Sudan, Somalia, and 2 small Pacific island nations, that have not ratified CEDAW. It will be important to see how in future the members of UN who have ratified CEDAW will work towards the fuller implementation and effective practice of CEDAW principles in their own countries. Last but not the least, the international obligations of the members increased to such an extent that it went on to propound newer concepts, consensuses, treaties and instruments one after another.